Amy Coney Barrett delivered the court's majority opinion in United States versus Tesla Inc., her voice measured but resolute as it carried through the ornate room, with cameras capturing the historic moment. In consideration of the unprecedented scale of data privacy violations and the deliberate circumvention of established regulatory frameworks, this court finds Tesla Inc. liable for statutory damages in the amount of $1 billion. Barrett stated firmly, leaving no room for ambiguity. She emphasized that the systematic collection and monetization of consumer data without meaningful consent violated federal privacy statutes at an unprecedented scale in American jurisprudence. The gallery erupted in hushed murmurs as legal observers exchanged shocked glances. Not since the antitrust cases of the early digital era had the court imposed such a significant penalty against a tech giant. Attorneys for the Department of Justice could barely contain their reactions. Their surprise at the scope of the victory was evident, while Tesla's legal team huddled in visible distress. What no one in the chamber could have anticipated was what would happen next. Within 48 hours, Elon Musk, the founder and executive chairman of Tesla, would make a move so unexpected and strategically brilliant that it would not only neutralize the court's billion-dollar penalty, but also transform the relationship between America's highest judicial body and the tech industry for decades to come. The confrontation between one of the court's most respected legal minds and one of the world's most powerful businessmen was about to take a turn that would leave the entire nation speechless. Before we dive deeper into this extraordinary legal clash, make sure to hit that subscribe button and turn on notifications so you don't miss our next analysis of the pivotal moments reshaping America's legal and business landscape. Associate Justice Amy Coney Barrett had already established herself as one of the court's most methodical and influential voices. Since her controversial confirmation in 2020, Amy Coney Barrett had emerged as one of the Supreme Court's principal jurists. At 52, the former Notre Dame law professor defied early critics who expected her to be a consistently partisan vote. Instead, she established a reputation for careful textualist analysis that sometimes led her to break with ideological expectations. The Tesla case marked the peak of Barrett's evolving jurisprudence on digital privacy. As technology reshaped everyday life, Barrett crafted a sophisticated framework for applying constitutional principles to modern data issues, drawing on her scholarly background to navigate the complex intersection of established legal doctrines and rapidly advancing technology. For Barrett, the stakes reached far beyond this single case. The court's credibility in the digital age hinged on its ability to effectively check the power of tech giants whose influence often surpassed that of traditional government institutions. Failing to establish clear boundaries would risk rendering the judiciary increasingly irrelevant in regulating the most powerful forces shaping modern society. Meanwhile, Elon Musk, now 53, had transformed Tesla from an electric vehicle startup into one of the most valuable companies in history. Although he stepped down as CEO in 2021, he remained executive chairman, focusing on strategic initiatives while advancing his space exploration ambitions through SpaceX. With an estimated net worth exceeding $200 billion, Musk commanded resources, rivaling those of many nations. But what truly made Musk formidable wasn't just his wealth. It was Musk's legendary strategic thinking that set him apart. Known for his first principles philosophy, which emphasizes constant innovation and bold risk-taking, he had consistently demonstrated an uncanny ability to turn apparent setbacks into opportunities for growth and market dominance. For Tesla, the $1 billion fine, while significant, represented less than 1% of its annual revenue. The true threat lay in the precedent it would set. If the Supreme Court's interpretation of the privacy statute stood, it would fundamentally disrupt Tesla's data-driven business model and potentially trigger similar lawsuits against major tech platforms. The legal community had expected Tesla to pursue traditional appeals or lobby Congress for legislative relief. No one anticipated that Musk himself would step in with a strategy aimed not only at contesting the fine, but also at challenging the very framework of how America's judicial system interacts with the tech industry. As legal experts nationwide pored over Barrett's 57-page opinion, Musk was already preparing his next move. Elon Musk convened an extraordinary meeting at Tesla's Fremont headquarters, bringing together not only the company's top attorneys, but also leading scholars in constitutional law, data ethics, and regulatory policy. An unusual gathering that hinted at the unconventional response they were crafting. Justice Barrett's opinion reflects a fundamental misunderstanding of modern data architecture, Musk reportedly told the experts, but it also presents an opportunity to reshape the entire conversation. Within 24 hours of the court's ruling, as media buzzed over the historic fine, Musk's team was already executing a multi-pronged strategy that would soon shock both supporters and critics of the decision. Barrett's opinion had methodically dismantled Tesla's legal defense, citing internal documents showing systematic efforts to collect user data beyond what Tesla's privacy policies disclosed. The opinion was especially harsh on what Barrett called notice theater, the practice of providing critical privacy information in a superficial or misleading way. Barrett criticized Tesla's use of lengthy, complex terms of service that no reasonable consumer could be expected to understand, writing that the company's claim of informed consent was incompatible with the deliberate complexity of their disclosure methods. Constitutional freedoms lose their substance when meaningful choice is rendered impossible through deliberate obfuscation, she declared. The opinion gained support from a rare coalition of justices, liberals like Sotomayor and conservatives like Gorsuch both sided with Barrett's textualist approach to interpreting the statute. Only Justices Thomas and Alito dissented, arguing the court was overstepping its authority and that such issues should be handled by the legislature. Meanwhile, legal analysts debated the ruling's far-reaching impact on privacy law and the tech industry. Tesla's official response was surprisingly restrained, a brief statement expressing disappointment and saying the company was reviewing all options. This unusual calm should have been the first sign that something unprecedented was underway. Just 48 hours after the court's ruling, Elon Musk released an open letter that appeared simultaneously on Tesla's website, as a full-page ad in major newspapers, and as sponsored content across digital platforms. Instead of launching legal objections, the letter began with a stunning concession. Justice Barrett's analysis of current privacy practices is substantively correct, Musk wrote, immediately grabbing national attention with his unexpected admission. The ecosystem of data collection that has evolved in the digital age has indeed outpaced both regulatory frameworks and consumer understanding. Rather than challenge the court's findings, Musk took a different approach. Musk shifted gears with a bold proposal that would redefine the entire conversation. Today, Tesla is not merely accepting the court's penalty, we are transcending it, he declared. Musk announced the creation of the Digital Rights Foundation, an independent organization endowed with $5 billion, 5 times the court's mandated fine, designed to establish a new framework for data rights in the digital age. The announcement sent shockwaves through legal, tech, and financial circles. Tesla's stock, which had fallen after the ruling, surged as investors recognized the strategic brilliance behind Musk's move. By voluntarily exceeding the court's penalty, he took control of the narrative, positioning Tesla as a leader rather than a defendant. But the most groundbreaking part of Musk's announcement was yet to come. I am extending a formal invitation to Justice Barrett to serve as honorary chairperson of the Foundation's Judicial Advisory Board upon her retirement from the court. For Barrett, the stakes reached far beyond this single case. The court's credibility in the digital age hinged on its ability to effectively check the power of tech giants, whose influence often surpassed that of traditional government institutions. Failing to establish clear boundaries would risk rendering the judiciary increasingly irrelevant in regulating the most powerful forces shaping modern society. Meanwhile, Elon Musk, now 53, had transformed Tesla from an electric vehicle startup into one of the most valuable companies in history. Although he stepped down as CEO in 2021, he remained executive chairman, focusing on strategic initiatives while advancing his space exploration ambitions through SpaceX. With an estimated net worth exceeding $200 billion, Musk commanded resources rivaling those of many nations. But what truly made Musk formidable wasn't just his wealth, it was his, Musk continued. Her intellectual rigor and commitment to first principles make her uniquely qualified to help create a framework that protects fundamental rights while fostering beneficial innovation. The invitation, which everyone knew Barrett couldn't accept while still serving on the court, was a brilliant strategic move. It subtly repositioned Barrett from Tesla's adversary to a potential partner in addressing the broader societal challenge. The gesture acknowledged her expertise while suggesting that real solutions would come not from punitive court rulings, but through collaborative innovation. Within hours, the White House, congressional leaders, and consumer advocacy groups were scrambling to respond to Musk's unexpected play. The Justice Department, which had hailed the court's ruling as a landmark victory, now faced the possibility that Tesla could emerge from the case with greater public support and even more influence over the privacy regulations meant to control it. Bound by judicial ethics from commenting on ongoing cases or engaging with litigants, Justice Barrett remained silent. But sources close to the court revealed she was deeply concerned, viewing the move as an attempt to co-opt judicial authority through private sector initiatives. As the public and media absorbed Musk's announcement, a second phase of the battle was just beginning. Tesla's strategy quickly unfolded as the company filed a formal motion with the court, not to contest the $1 billion judgment, but to request a change in how the penalty would be enforced. Instead of paying the fine directly to the Treasury, Tesla proposed creating a court-supervised restitution fund that would compensate affected consumers directly while also funding research into privacy-protecting technologies. This move was brilliantly calculated. It forced the court to choose between denying consumers direct compensation, which would appear to prioritize government revenue over victims, or engaging with Tesla's alternative framework, thereby giving legitimacy to Musk's approach. Either outcome would strengthen Tesla's position while undermining Barrett's moral high ground. As legal experts debated whether Musk had outmaneuvered the court or put Tesla in greater legal risk, the stage was set for an unprecedented clash between judicial authority and corporate power. The next move rested with Justice Barrett and her colleagues, whose response would determine if the court could uphold its authority against Musk's bold strategy. 3 weeks after Musk's announcement, the Supreme Court issued an unusual supplemental order in the Tesla case, authored by Barrett. The 5-page document addressed not only Tesla's motion, but also the wider implications of Musk's public campaign. This court acknowledges the defendant's right to engage in public advocacy regarding matters of law and policy, Barrett wrote in her characteristically precise style. However, attempts to recharacterize judicial remedies as optional guidelines from which private entities may substitute their preferred alternatives. The supplemental order made it clear that Tesla's motion fundamentally misunderstood the nature of judicial authority under Article 3 of the Constitution. Barrett firmly rejected the request to restructure the penalty, emphasizing that Tesla's proposed alternative improperly sought to turn a judicial remedy into a private governance system beyond the court's oversight. Her opinion made it clear the court would not be outmaneuvered by even the most sophisticated PR strategy. Most notably, Barrett directly addressed Musk's invitation for her future involvement with his foundation, stating, "The independence of the judiciary requires not only freedom from actual conflicts, but also from the appearance of entanglement with litigants. Members of this court cannot and will not be enlisted, even prospectively, in private regulatory schemes established by entities subject to our jurisdiction." This forceful response reaffirmed the court's authority and exposed the strategic nature of Musk's move. Legal scholars immediately recognized the historical weight of Barrett's order, with one constitutional law professor calling it the judicial equivalent of calling a bluff in high-stakes poker. But what happened next showed why Musk is one of the world's most successful business leaders. Instead of seeing Barrett's rebuke as a defeat, he made a swift, nimble pivot that turned a potential humiliation into a fresh opportunity. In a televised interview just hours after the court's order, Musk appeared thoughtful and reflective rather than defensive. Justice Barrett is absolutely right about the separation of powers. For Barrett, the stakes reached far beyond this single case. The court's credibility in the digital age hinged on its ability to effectively check the power of tech giants whose influence often surpassed that of traditional government institutions. Failing to establish clear boundaries would risk rendering the judiciary increasingly irrelevant in regulating the most powerful forces shaping modern society. Meanwhile, Elon Musk, now 53, had transformed Tesla from an electric vehicle startup into one of the most valuable companies in history. Although he stepped down as CEO in 2021, he remained executive chairman, focusing on strategic initiatives while advancing his space exploration ambitions through SpaceX. With an estimated net worth exceeding $200 billion, Musk commanded resources rivaling those of many nations. But what truly made Musk formidable wasn't just his wealth. It was his Musk acknowledged sincerely. My invitation was well-intentioned but inappropriate, and I thank her for the clarity of her response. Then came the unexpected twist. Musk emphasized that the court's supplemental order made it clear no single entity, government or private industry, can solve these challenges alone. We need a new framework that respects judicial authority while allowing room for responsible innovation, he said. Musk announced that Tesla would pay the $1 billion fine in full without further appeal and move forward with establishing the Digital Rights Foundation, now restructured as an independent trust. Governance of the foundation would be shared among consumer advocates, academic experts, and industry representatives, with strict safeguards preventing Tesla from having controlling influence. The foundation will operate with full respect for the judiciary's role, Musk explained, while focusing on fostering private innovation and self-regulation. Musk's approach cleverly emphasized how private innovation can complement, not replace, legal remedies. This smart repositioning let him keep the positive parts of his plan while stepping back from the elements Barrett saw as a challenge to judicial authority. The move was so smoothly handled that many didn't realize. Tesla's core business goals were still fully protected despite the seeming concession. What followed was a masterclass in turning adversaries into collaborators. Tesla unveiled a range of privacy-enhancing technologies that gave consumers unprecedented control over their data, while still supporting the personalized services crucial to its business model. These innovations allowed Tesla to fully comply with Barrett's ruling while preserving key features of its data ecosystem. The company also overhauled its privacy policy, replacing dense legal jargon with clear, graduated options that were easy for consumers to understand. Tesla's new privacy approach delivered clear, timely choices to users, boosting customer engagement while reducing the company's legal risks. In effect, Musk turned a $1 billion penalty and a judicial rebuke into a strategic repositioning that strengthened Tesla's market standing, improved its regulatory reputation, and established the company as a leader in digital rights, all while respectfully accepting the court's authority. The business world was amazed by the sophistication of Musk's response. As one analyst noted, he transformed what could have been Tesla's darkest moment into a showcase of why he's seen as the most formidable business strategist of the digital age. By fully complying with the ruling, Musk actually reinforced Tesla's long-term position. For Justice Barrett, the outcome was a nuanced victory. The court's authority remained intact, and her privacy jurisprudence stood firm. But Musk had effectively shifted how those principles would be applied. from strict judicial enforcement to a more collaborative, innovation-driven path. The shift moved the approach from a purely punitive framework to one that could advance Tesla's business interests while still addressing core privacy concerns. As things settled, observers across the political spectrum realized this wasn't just a legal battle, but a historic negotiation between two major power centers in modern America, the Supreme Court and the tech industry, with Barrett and Musk as their leading figures. The Barrett-Musk showdown quickly went beyond the Tesla case, becoming a defining moment in the evolving dynamic between traditional governance institutions and the digital platforms now central to economic and social life. Legal scholars began referencing the Barrett doctrine of digital privacy, highlighting key principles from her majority opinion. Meaningful consent must involve true understanding, not just formal agreement. Large-scale data collection can shift privacy harms from individual to systemic, and courts should impose remedies proportional to a company's global reach rather than limits suited only to smaller players. Business schools soon developed case studies on what became known as the Musk pivot, the strategic skill of accepting adverse rulings while turning them into competitive advantages. Tesla's response became a model for corporate resilience, showing how regulatory challenges could spark innovation rather than just create compliance burdens. Despite its controversial beginnings, the Digital Rights Foundation evolved into a truly independent body that helped shape privacy standards later adopted by international regulators. Its work on graduated consent, offering privacy choices in manageable steps instead of all-or-nothing terms, became especially influential, creating a balance between business interests and genuine consumer control. For Justice Barrett, the stakes reached far beyond this single case. The court's credibility in the digital age hinged on its ability to effectively check the power of tech giants whose influence often surpassed that of traditional government institutions. Failing to establish clear boundaries would risk rendering the judiciary increasingly irrelevant in regulating the most powerful forces shaping modern society. Meanwhile, Elon Musk, now 53, had transformed Tesla from an electric vehicle startup into one of the most valuable companies in history. Although he stepped down as CEO in 2021, he remained executive chairman, focusing on strategic initiatives while advancing his space exploration ambitions through SpaceX. With an estimated net worth exceeding $200 billion, Musk commanded resources rivaling those of many nations. But what truly made Musk formidable wasn't just his wealth. It was his Tesla case solidified her reputation as a jurist who could apply traditional legal principles to cutting-edge technological issues. Her approach won unexpected praise from both liberal consumer advocates, who valued her defense of individual privacy, and conservative judges, who admired her textualist analysis and judicial restraint. In academic circles, the Barrett-Musk confrontation reignited debates about the future of law and technology. Interest grew in how governance operates when private entities rival or even surpass the power of government institutions. The Tesla case became a staple in law school and business ethics courses, studied from multiple angles, as a triumph of judicial authority, a masterclass in corporate adaptation, or sometimes both simultaneously. Perhaps most importantly, the confrontation set a new precedent for resolving conflicts between tech platforms and traditional governance, not through a winner-takes-all battle, but by fostering substantive accountability while allowing room for ongoing innovation. 3 years after the original ruling, Justice Barrett publicly addressed the case for the first time during an academic lecture on technology and the Constitution. Without naming specific parties, she outlined a vision for judicial engagement, with technological change that balances applying enduring constitutional principles with the challenge of interpreting them in new contexts. The framers of the Constitution could never have anticipated every future circumstance, Barrett observed, but the Constitution's lasting strength lies not in predicting every detail, but in its adaptable framework. Barrett emphasized that the Constitution's true strength lies not in predicting every technological shift, but in establishing principles flexible enough to safeguard fundamental rights across eras while enabling society to reap the benefits of innovation. Musk, meanwhile, applied lessons from the confrontation to Tesla's long-term governance strategy, creating an internal constitutional framework that proactively addressed regulatory concerns. Privacy and transparency principles became core to Tesla's product development from the outset, rather than as afterthoughts. In a remarkable turn, elements of Barrett's judicial reasoning and Musk's strategic implementation were eventually merged into federal privacy legislation that set clear boundaries while encouraging responsible innovation. The bill, which passed with rare bipartisan support, showcased how adversarial clashes between major institutions could produce effective governance solutions. For everyday Americans, the outcome was a digital landscape that increasingly respected their privacy choices while maintaining the conveniences of personalized services. The informed consent mechanisms Tesla pioneered in response to Barrett's ruling became industry standards, empowering consumers with real control without needing technical expertise. As emerging technologies like AI and augmented reality posed new governance challenges, the Barrett-Musk showdown stood as a valuable precedent for balancing innovation with accountability. America's legal and entrepreneurial traditions proved they could engage in productive tension rather than irreconcilable conflict. Judicial authority and technological innovation were not sacrificed. Instead, both were strengthened through mutual engagement. The key lesson transcended the specific personalities and technologies involved. In a functional democracy, even the most powerful institutions must engage in mutual accommodation, not by compromising core principles, but by understanding that their long-term goals may be better achieved through adaptation rather than rigid confrontation. As the nation faces the unprecedented challenges of the digital age, this lesson will be crucial for the years ahead. If you found this analysis of the historic Barrett-Musk confrontation insightful, please like and subscribe for more in-depth coverage of the legal and business events shaping America's future. Share your thoughts in the comments. Do you think this case has permanently shifted the balance of power between the judiciary and tech giants? Your engagement helps us continue to bring you thoughtful analysis of today's most impactful stories.